Welcome, folks. Today is the first edition of the video that I've recorded to highlight one of the Supreme Court judgments in the Civil Appeal number 20825 to 20826 of 2017. This is a reportable judgment in the matter of Arjun, Panditrao, Khotkar, the appellant, versus Kailash, Kushanrao, Gorantyal and others, the respondents. The judgment was delivered by R.F. Nariman, the learned Supreme Court judge. The net summary is that the IA number 13044 of 2019 for intervention in CA numbers 20825 and 20826 of 2017 is allowed. The next paragraph, para number 2, goes on to narrate that these civil appeals have been referred to a bench of 3 honorable judges of the Supreme Court by a division bench, reference order dated 26 July 2019. Dealing with the interpretation of section 65B of the Indian Evidence Act by 2 judgments of the Honorable Supreme Court. The reference order, after quoting from ANVAR, Anwar PV versus PK Bashir and others, it's a 2004 judgment. The citation is 2014, volume 10, SCC, page number 473, delivered by a 3-bench decision of this of the Honorable Supreme Court, wherein it was found that a division bench in the specially petition criminal number 9431 of 2011 reported as SHAFHI Shafi Mohammed versus the state of Himachal Pradesh. It's a 2018 judgment, volume 2, SCC 801, which may need reconsideration by a bench of a larger strength. The factual matrix, para 3, the brief facts necessary to appreciate the controversy in the present case, as elucidated in the Civil Appeals number 20825 and 20826 of 2017, are as follows. There were 2 election petitions by the present respondents before the Bombay High Court under Section 80 and Section 81 of the Representation of People's Act 1951, challenging the present appellant, namely Shri Arjun Panditrao Khotkar, who is the returned candidate hereinafter referred to as RC, belonging to the Shiva Sena party from 101-Jalna Legislative Assembly constituency to the Maharashtra State Legislative Assembly for the term commencing November 2014. As the facts go on, there are a series of issues, and I am proceeding directly to each of the several pages here. So page 15, 16, 17, 18, 19, 20, 21, 22, 24, 25, 26, 27. I'm going to go into the double page mode, as you can see. 29, 30, 31, 32, page 32 is actually delving into the subsection 2 to 5 of section 65B of the Indian Evidence Act, which is being reproduced in the para number 27 of the judgment, wherein a reproduction of the subsection 2 to 5 of section 5 of the Civil Evidence Act 1968 with minor changes. Section 69, this is section 69 of the UK Police and Criminal Evidence Act 1984 with evidence from computer recordings in criminal proceedings. This is a UK an act from United Kingdom is being used to interpret Section 65B. Section 69 reads thus, subpara 1, Section 69, subsection 1, in any proceeding, comma, a statement in a document produced by a computer shall not be admissible as evidence of any fact stated therein unless it is shown, A, that there are no reasonable grounds for believing that the statement is inaccurate because of improper use of that computer. B, that at all material times the computer was operating properly, comma, or if not, comma, that any respect in which it was not operating properly or was out of operation was not such as to affect the production of the document or the accuracy of its contents. And C, that any relevant conditions specified in rules of court under subsection 2 below are satisfied. Subsection 2 of Section 69, provision may be made by rules of court requiring that in any proceedings where it is desired to give a statement in evidence by virtue of this section, such information concerning the statement as may be required by the rules shall be provided in such form and at such time as may be so required. So with this said, I would proceed to highlight page number 33, page number 34, 35, 36, 37, 38, 39, 40, page number 39, para number 33 talks about Vikram Singh and another versus State of Punjab and another. It's a 2017 volume 8 SCC 518, a 3-bench judgment of the Supreme Court. Again, followed the law laid out in Anwar PV Supra, clearly stating that where primary evidence in electronic form has been produced, no certificate under Section 65B would be necessary. This was so stated as follows. Para 25, the Learned Counsel contended that the tape recorded version has been relied on without there being a certificate under Section 65B of the Evidence Act 1872. Full stop. It was contended that audio tapes are recorded on magnetic media, the same could be established through a certificate under Section 65B. And in the absence of the certificate, the document which constitutes electronic record, cannot be deemed to be a valid evidence and has to be ignored from consideration. Reliance has been placed by the Learned Counsel on the judgment of this court in Anwar PV versus P.K. Bashir. The conversation on the landline phone of the complainant situate in a shop was recorded by the complainant. The same cassette containing conversation by which ransom call was made on the landline phone was handed over by the complainant in original to the police. This court, in its judgment dated 25/1/2020, which is 25th of January 2020, has referred to the aforesaid fact and has noted the said fact to the following effect. Para 5. The cassette on which the conversations had been recorded on the landline was handed over by Ravi Verma to SI Jeevan Kumar, and on a replay of the tape, the conversation was clearly audible and was heard by the police. Para 26 of that judgment, which is Vikram Singh and another Supra, the tape recorded conversation was not secondary evidence which required certificate under Section 65B, since it was the original cassette by which a ransom call was tape recorded, there cannot be any dispute that for admission of secondary evidence of electronic record, a certificate was contemplated by Section 65B is a mandatory condition. There's a footnote 4, the definition of data, electronic form and electronic record under the Information Technology Act 2000 as set out herein above makes it clear that data and electronic form include magnetic or optical storage media, which would also include the audio tape / cassette discussed in Vikram Singh matter, Supra.